What to do if you receive a federal target letter. You check your mail, and there's a letter from the United States Attorney's Office. You just received what's called a target letter from federal prosecutors. What does this mean? Should you panic? And what should you do next? Hi everyone, I'm Michael Lowe, and in today's video, I'm breaking down everything you need to know about federal target letters in grand jury investigations. This is critical information that could make the difference between years in prison and a favorable resolution. Let's dive in. Federal grand juries. Unlike state criminal cases, federal agencies like the FBI and DEA work with federal prosecutors called Assistant United States Attorneys, or AUSAs, to investigate crimes independently from local law enforcement. So what exactly is a federal grand jury? A federal grand jury serves two main purposes. First, to investigate crimes and initiate criminal proceedings. Second, to protect citizens from facing charges without sufficient evidence. Essentially, the grand jury decides whether there's probable cause that a federal crime was committed. If they find probable cause, they issue an indictment. If not, the case is no billed, meaning it doesn't move forward. Here's something crucial to understand. The AUSA is the only lawyer in that grand jury room. No defense attorney is present. The prosecutor advises the grand jury on the law and presents all the evidence, both documents and live testimony. This is why getting proper legal representation early is so important. Witnesses versus subjects versus targets. The federal government categorizes people into three groups: witnesses, subjects, and targets. Witnesses have information about the case. They testify under oath, but they're not suspected of any crime. They're just providing facts. Subjects are people under suspicion of wrongdoing according to the Justice Department's definition. A subject is someone whose conduct falls within the scope of the grand jury's investigation. You're on their radar, but they haven't decided to charge you yet. Targets are the opposite end of the spectrum. If you're labeled a target, the federal prosecutor believes they have substantial evidence linking you to a crime, and you're considered a putative defendant, meaning they're planning to charge you. Here's what most people don't know. These categories are not set in stone. The AUSA can change your status as the investigation develops. You might start as a witness and become a subject, or go from a subject to a target as new evidence emerges. While there's no federal law requiring prosecutors to tell you which category you're in, current Justice Department policy is to advise people when they're considered a subject or a target. And that's where the target letter comes in. What is a target letter? A target letter is exactly what it sounds like: a letter notifying you that you're a target of a federal criminal investigation. This letter might come separately in the mail, be delivered by an FBI agent, or be attached to a grand jury subpoena. However it arrives, it will include specific advice of rights language that the Justice Department requires. The letter will tell you that a grand jury is investigating possible violations of specific federal criminal laws, that you have the right to refuse to answer questions that might incriminate you, that anything you say can be used against you, that if you have a lawyer, you can step outside the grand jury room to consult with them. Which specific federal crimes are being investigated? Let me share a real example. I recently represented a client who had a target letter hand-delivered by an FBI agent. The agent then tried to interview her about health insurance fraud allegations right there on the spot. Fortunately, she knew better than to talk without a lawyer. And that brings us to the most important question. What should you do if you get a target letter? If you receive a target letter, you essentially have two options. Option number one, ignore the letter, wait for the indictment, and mount a vigorous defense at trial. Option number two, hire an experienced federal criminal defense attorney immediately and explore whether cooperation might benefit you. Now, I want to be clear, cooperation isn't right for everyone, but here's why it might be worth considering. The AUSA who sent that target letter often has specific reasons for reaching out. In many cases, they believe you have valuable information about a larger conspiracy or other defendants. They're signaling that there might be room to negotiate. When I received that target letter from my healthcare fraud client, it was immediately clear to me that while she had criminal liability, she also had knowledge about a much larger conspiracy. The prosecutor viewed her as a valuable witness against bigger players. This is where an experienced lawyer can make all the difference. I can assess whether you truly have leverage and how to use it to your advantage. The Proffer agreement. So how does cooperation actually work? Through something called a Proffer agreement. A Proffer agreement is an informal immunity agreement that protects you from having your statements used against you, with certain limitations based on specific language negotiated. Think of it as a protected conversation. You sit down with the prosecutors, your lawyer is there, and you tell them what you know. The agreement ensures that your statements during this proffer session have limited use against you. This is not a formal plea agreement yet. It's an informal negotiation where you demonstrate your value as a cooperating witness. If you're truthful and provide useful information, then your lawyer and the prosecutor will negotiate a formal plea agreement that might include reduced charges, lesser sentencing recommendations, or limited immunity from prosecution. Why would anyone want to do this? Two major reasons. First, you can present your conduct in proper context. Maybe you were involved, but your role was minimal. Maybe you were coerced or didn't understand what was happening. A proffer lets you tell your side of the story to generate some sympathy. Second, you can negotiate a much better outcome. If cooperating helps the government build cases against more significant defendants, they might offer you a deal that keeps you out of prison or significantly reduces your sentence. The strategic advantages of cooperation. Timing matters enormously. If my client is among the first cooperators in a conspiracy investigation, they stand to gain much more than someone who waits until later. The government values early cooperation more highly because it helps them build their case, but cooperation doesn't end at the proffer meeting. You can continue to cooperate as the case proceeds to trial. Continued cooperation can result in what's called a 5K1 motion, a sealed filing by the prosecutor asking the judge to sentence you below even mandatory minimum sentences because of your substantial assistance. This is especially crucial in drug cases and other federal crimes with mandatory minimums. The judge has very little discretion in these cases unless the prosecutor files that 5K1 motion or another provision applies. I've seen cooperation turn what could have been a 10-year mandatory minimum sentence into probation. But it requires strategic timing and an attorney who knows how to negotiate these agreements effectively. What the government might already know. Before we wrap up, I need to warn you about something critical. If you've received a target letter, the federal government has likely been investigating you for months or even years. They might have wiretaps on your phone conversation at work or home, search warrants for your computer, phone, and documents. Cooperating witnesses who are already providing information about you, possibly friends, family, colleagues, or coworkers. The scope of federal investigative powers is enormous. They don't send target letters lightly. By the time you receive one, they typically already have significant evidence. This is exactly why you need experienced federal criminal defense counsel immediately. Not to destroy evidence or obstruct justice, but to protect your rights and explore your options before it's too late. Conclusion. Receiving a federal target letter is terrifying, but it's not necessarily the end of the world. With the right attorney and strategy, a target letter can be an opportunity to cooperate, provide context, and negotiate a resolution that's far better than what you would have faced if you had been indicted. But you have to act quickly. The window for cooperation closes fast. If you or someone you know has received a target letter or been contacted by federal agents, don't wait. Don't try to handle it yourself. And do not speak to investigators without a lawyer present. The stakes are too high, and the system is too complex. If you found this video helpful, please hit that like button and subscribe for more content on federal criminal defense. Drop any questions in the comments below. I read every single one. And remember, if you're facing a federal criminal investigation, your next call should be to an experienced federal criminal defense attorney. Thank you for watching, and I'll see you in the next video.